So as I started to explain in my previous video, the Oregon Supreme Court has essentially legalized rape and overturned rape laws in the state. They issued a ruling just last week, the day after they announced that my petition for review in my case would be denied. They went to bat for a rapist and overturned his case. And let's look at why here. This is State of Oregon versus Austin Ray Haltom. The decision of the Court of Appeals is reversed, the judgment of the Circuit Court is reversed, and the case is remanded to the Circuit Court for further proceedings. They start to go into here about the term without consent. First of all, they're using a standard as it relates to motor vehicle theft. They're using that standard of without consent because I guess that's the only way that that is defined in Oregon laws here. So they are applying that to this rape case. Defendant in the present case was convicted of an entirely different crime, of which lack of consent is an element. Second-degree sexual abuse, as defined by ORS, blah, 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 subjecting another person to sexual intercourse or certain sexual acts when the victim does not consent thereto. He contends that the does not consent element of ORS, blah, 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 the motor vehicle theft one, plays a similar role to that of the without consent element in the unauthorized, unlawful use of a motor vehicle statute in, at issue in Simonoff, which I guess is some other case law thing here. In that so far, ORS 163.425 does not specify a mental state that attaches to the does not consent element. Both the analysis and ultimate conclusion in Simonoff apply and establish that knowingly is the minimum mental state that attaches to the does not consent element. Therefore, he argues, to convict him under ORS 163.425, the state was required to prove that he had engaged in sexual intercourse with the victim, knowing that she did not consent, and that the trial court therefore erred when it denied his request for an instruction to that effect and entered in a judgment of conviction based on a jury finding that he had merely been reckless with respect to the victim's consent. Based on the analysis set out below, we conclude that the trial court erred and that the judgment of the trial court and the Court of Appeals decision affirming that the judgment must be reversed. And then it goes into the background of the case here. The relevant facts are undisputed, which may or may not be the case because they had all these undisputed facts completely wrong in my case. Defendant was prosecuted on charges of first-degree rape and a lesser-included offense, second-degree sexual abuse as defined in ORS 163.425, based on evidence that the morning after having had consensual intercourse with his 17-year-old then-girlfriend, he insisted on having intercourse again, ignoring her when she told him that it hurt and that she did not want to. And persisting as she lay there frozen and crying. Other evidence submitted at trial, including defendant's own testimony, raised factual issues as to whether defendant had understood the victim's protest and conduct as a refusal. At trial, the parties disagreed about the minimum mental state that attached to the does not consent element of a second-degree sexual abuse charge. Defendant sought a jury instruction requiring the jury to find that he had acted with knowledge of the victim's non-consent in order to convict, while the state sought an instruction that the jury could convict if it found defendant's mental state with respect to the victim's non-consent had been knowing, reckless, or criminally negligent. The trial court rejected defendant's argument that the does not consent element of second-degree sexual abuse was analogous to the without consent element in the unauthorized use of a vehicle crime at issue in Simonoff, and required that same analysis, and ultimately the same minimum mental state, knowing, was found to apply in that case. So, blah, 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 they go on for 34 pages here to justify that a woman saying, no, I don't want to, does not constitute a rapist knowing that she is not consenting. So the Oregon State Supreme Court has essentially legalized rape. What more does a woman have to do other than say, no, I don't want to? Does she have to physically struggle? Does she have to state the exact words, I do not consent? Does she have to state some other sentence, some specific line of words to communicate she does not consent? So apparently you have the Oregon State Supreme Court here. This is Judge Adrian Nelson is basically writing this whole thing here, this 34-page ruling here, to basically justify how it's legal to rape a woman. It's legal to force yourself on her and have sex with her when she's saying, no, I don't want to. It's not a crime now to do that, according to the Oregon State Supreme Court. These are the same excuses for human excrement who refuse to hear my case of self-defense. What's interesting here is they're playing this all about the mindset of the defendant, when they ruled in my case that the mindset of me is completely irrelevant as it relates to self-defense. These are sick, disgusting individuals here that we're dealing with, and that's who I'm fighting. Please help me in my fight to take my case to the Supreme Court. Please look at the other videos on my channel if you're new to this and you're coming across this by happenstance. I was the news videographer who was out filming a protest a few years ago. I was attacked by a gang, and I defended myself against them, and then I was the one hauled into court on multiple felonies and found guilty after I didn't harm a fly, and I tried to get away from the situation. So that's what we're dealing with here. That's why I need to take my case to the federal Supreme Court. Thank you all for watching.